Philippe, I think it's fine to just talk without raising hands and stuff.
Oh, great. Good.
Okay. Uh, Welcome everyone to the October 8th Governance Subcommittee meeting. I'm Susan Manderberg, Chair of the Subcommittee and Co-Chair of the Commission. We have a number of things to get through today, so I'd like to just start in. The first thing on the agenda is the updates to the Commission bylaws. Um, I propose that we talk about this in three different um, subheadings. One is the proposed amendments that I've made and circulated. I haven't received through Mara any written comments, and obviously I haven't received any oral comments on my suggestions. So we'll look at those first. There are a couple of new sort of relatively minor issues I'd like to add. The second thing I'd like to discuss is the issue that I sent a subsequent memorandum on, and that's been posted on the actual conflicts of interest. And the third thing I'd like to discuss is the audit committee. So starting in on the amendments that I proposed, I sent out, and there have been posted a track changes version of those proposals and also a clean version of those proposals. Some of them are very, very relatively minor changes dealing with outline form, grammar, syntax, putting things in conformity with the new statutes and with the actions of the 2023 legislature. I don't imagine any of those are controversial, but I'll stop to see if either Rob or Philippe think they are.
No, but if Susan, if you could try to point us to where you think the more substantive ones are, because I know from, you know, I've looked at it, but I it's been a long time since I parsed over statutes, and so any kind of pointing us to those specific substantive changes would be helpful, like down the line.
Well, the most specific substantive changes have to do with us not any longer being an independent commission. In other words, we now submit our budgets to the governor as opposed to the legislature, and we are not allowed to testify in opposition to the governor's budget. A second major change is in the ability of the governor to appoint the executive director. We used to appoint our own executive director. And there have been some changes in how the governor can terminate people on the commission and the executive director. So those are all sort of spelled out in there. The the more substantial proposals that I've made, I believe, are the following. I suggested two new definitions that weren't in the existing bylaws. One is to define action item, and the other is to define what we mean by in writing, because those terms are used in various other parts of the bylaws. Any comments on those proposals? Okay, in Article 2 of the bylaws, um, there's a section on how the commission members should get permission to communicate with staff. So under the existing bylaws, there's a provision that was put in there for a couple of different reasons. One was to make sure that somebody, in other words, the executive director, was aware of the kinds of communications that were going on between staff and commission members so that some consistency and overview would be possible. And second of all, when we discussed in beginning of 2023, these new bylaws, there was some feeling that staff needed to have some protection if they were accused of communicating improperly with commissioners. And the procedures that are in the existing bylaws are very, very clunky and difficult to follow, and I suspect not being followed. And so the proposal um, does require staff and commissioners to have some uh, approval by the executive director, but it leaves it to the executive director to set out whatever mechanisms the executive director thinks will work well to keep both the commission and the agency functioning efficiently. Um, so the change is that we don't set out what procedures are to be followed. We give that task to the executive director. Are there any comments or input on that? Okay, the next thing is under in Article 3. Um, as I mentioned before, the new statute allows the governor to appoint the executive director of the commission, but it says that the governor has to do that in consultation with the commission, but specifically in consultation with the chair of the commission. Um, but it doesn't leave out the possibility of consulting with the entire commission. So um, I believed as I mentioned in the comments that I made, that it would, I think, be important for us to um, acknowledge in the bylaws that the commission itself should have a role and might have a role in consulting on who the new executive director might be, and basically spelling out that's within our power. Um, Another part in Section 1B in Article 3 is regarding the timing of the executive director evaluation. Let me just stop and go back to the 1A6 with the consultation with the governor regarding a new executive director. Any comments about that? Okay, going on to 1B3 in Article 3. Um, the governor's memo about agency expectations, which came out recently, says that a commission should review the executive director performance every 2 years. It doesn't give a month or a starting year, but the Department of Administrative Services, DAS, has published a schedule that it wants us to follow. And it wants us to do one in June 2026 and every 2 years after. So I put that in the amendments. We don't have to be that specific. We can just say to do it every 2 years. I don't think it matters one way or the other. But if we're this specific and things change, then we would have to change the bylaws. So we could just say having executive director evaluations as required by the Department of Administrative Services. That would probably be cleaner. Everybody okay with changing it to that?
I actually like setting out a time, honestly, because then we know when it has to be done, and it's not, oh well, we got another 3 months to do this. So I personally like that. I understand your thinking on this, and if everyone else thinks that's a better idea, that's fine.
I'm agnostic. One would require possibly amending the bylaws if DAS changes their minds. Um, that would not be necessarily very hard to do. It would just take a vote. Anybody else? Philippe?
I mean, I like the flexibility, right? I think flexibility tends to be in our favor generally, but I don't think it's a big deal in either direction. So I would be happy to go with whatever folks.
Everybody
Um,
feels strongly about this, I see. Okay, we'll keep it the way it is. Section 2E in Article 3, it deals with who orders uh, an audit report to the commission. The current bylaws say the commission should order the audit report. the commission has no direct control over staff, and so it's cleaner to just say that the executive director should ask for the audit report to be given to the commission. So that's the only change there. Any questions on every? Paul likes that. Okay, then under Article 4, Section 2, I thought it was a good idea to list the different types of meetings that we get to have as a commission and to define what those meetings are so they don't get confused. One of the things that we've been doing lately is having work sessions, which are not authorized by the current bylaws. And so I thought it was important to get that in there, and then to just set out how work sessions, how commission meetings and informational meetings and emergency meetings and executive sessions and work sessions are all different from one another. So I took a stab at doing that.
Well, if I could just ask a question. I've been dealing with the work sessions as public meetings. So we're calling them work sessions, but they're treated as far as I've been considering them to be regular commission meetings. The difference being that we don't have public comment, which we don't have to have, but I've been having them noticed as commission meetings. If we're going to have an action item, obviously noticing that there's an action item. I've been making sure that we adhere to all the public meeting requirements about meetings. So I think that rather than setting out a separate work session as a type of meeting, I think you leave it as a regular commission meeting, but somehow just change or maybe just say that some commission meetings can be designated as commissioner work sessions or something. But I don't think we should change that to be a type of meeting, because really there's only 3 types of meetings that we're allowed to have. And that is a regular meeting, an emergency meeting or a special meeting, and an executive session. Those are the only 3 that are authorized under the statute, I think.
Yeah,
And so I think we should stick with those 3, and then we can call them, we can talk about the different types of business that we're going to be conducting during those meetings, but they should still be just a regular meeting or a special emergency meeting or an executive session. I don't know what other people think, but
I have no problem with that. And I certainly didn't mean to suggest that we were doing anything wrong.
right. I know.
Yeah, no, I didn't mean to suggest that because I don't think we are. And I do agree with you that it's cleaner. So I will take a stab at redoing that so that I have some language in there that indicates that some commission meetings can be designated as work sessions that do not allow public comment. Everybody okay with that? All right. Moving right along, section 4D in Article 4. So the current bylaws say that we have to have a quorum not only to vote, obviously you need a quorum of voting members to vote on an action item. The current bylaws say that you need to have a quorum of voting members even to discuss what could possibly be an action item. And that strikes me as unnecessary. And it also strikes me as inefficient. For example, say we have an action item noted for a commission meeting, and unexpectedly, we don't have a quorum of voting members. Under the current bylaws, technically, we shouldn't even be discussing that topic because we don't have a quorum. And one of the ways it could come up is if we, for example, start having a quorum, start having a discussion, and for some reason, a voting member has to leave the meeting all of a sudden, destroying the quorum, then what we would have to stop the discussion. So we also have these work sessions where we discuss things that eventually may show up as action items. And having it in the bylaws that you need a quorum to discuss something that may at some point be an action item strikes me as tying our hands unnecessarily and creating inefficiencies that keep us from accomplishing our mission. So do I have any responses to that?
I mean,
Uh,
that makes a lot of sense to me.
we need, I don't remember, and I'm trying to look it up really quickly, what the rules are about that. What happens if you don't have a quorum? Are we allowed to discuss? I mean, I thought we took the language in the bylaws directly from the public meeting rules, but I don't remember.
We took the language from the bylaws, as I recall. We based the 2023 bylaws on the PDSC bylaws. That's my recollection. And
Yeah,
I
I mean,
I
that's in a
don't
public meeting, so I guess that's the thing. It's not considered a public meeting, maybe, if you don't have a quorum of voting members. And so we've always erred on the side of, obviously, we've had this discussion, right, about whether or not we need to terminate the meeting if we don't have a quorum, and Floyd educated us and said, no, it's just like an informational meeting as opposed to but I think then what happens is you no longer have a public meeting. And if you don't have a public meeting, you can't have a discussion about items that might lead to a decision. But I think that's worth looking at that those rules.
I'll look at them again. I don't remember that in the rules, but I will say that the administrative rules for the Government Ethics Commission came out after
Right.
we did these bylaws. We did these bylaws in spring 2023, and the administrative rules for the Oregon Ethics Commission were not adopted until October 2023. And so we couldn't have been looking at those. It would have had to be the statute. But I will go back and I will look at all of that again and I'll report back.
Can I ask a quick point of clarification or question? Um, do we have like a AAG or someone that we can ask, or a general counsel for clarification on these types of things? Like someone that we
So,
can just get the answers?
no.
No.
So here's the situation on that. We had a general counsel in spring of 2023, and much of what we did in the bylaws was based on that person's advice. In the interim, the legislature eliminated, Jennifer, you could probably explain this better than I can, but the legislature eliminated the position of general counsel for OPDC. And so now what we have is a very small budget to go to the Attorney General's department and ask for legal advice. And the legal advice that you get from them is very expensive.
I,
And so in order to be good guardians of our budget, we need to be extremely mindful of what kinds of questions we ask them to weigh in on.
I
I mean,
would I would suggest, however, that once we do this draft revision of the bylaws, that we do send them to DOJ for review.
Yeah,
And then we can get, if there's something in there that's inconsistent with the law, we can get review on that. But it used to be much easier to have these questions answered. And now we're just plodding through on our own, and Susan's been doing it with her time and research.
such as it is. But
can
yes,
I just say that that might be something worth trying to talk about or consider, just because it seems to me like we use the Attorney General in my office in Washington State, but it's like a contract, so we don't pay per per individualized question, and it's effective counsel. But if you're really like counting pennies for general counsel, not just us, but the agency itself, that seems like that's not the best, highest use of agency time or resources, and maybe something that we should think about addressing kind of in the long term. Just a thought. I know there's a lot of context I don't have, but it seems like a problem.
You're absolutely right. It's a huge problem, and it is a problem that was raised with the legislative fiscal folks who eliminated that position, and their position was that other executive branch agencies don't have general counsel. That's what DOJ is for. Um, and the juxtaposition of this was we didn't ask for money for DOJ in our budget because we had general counsel, but then they eliminated the general counsel position, and we didn't get money for DOJ because we didn't ask for it. But of course we didn't ask for it because we didn't have general, because we didn't need it because we had general counsel. So in the next, it's this whole dog chasing the tail thing. So in our next budget, there has to be money for DOJ, more money than we have now to seek legal advice from DOJ for sure.
Bottom line is this was part of the transition from the judicial branch to the executive branch that we didn't anticipate. Why didn't we anticipate it? Because we didn't have good guidance on it. So, you know, this is where we're at now. I will go back. I will look at I'll look at the law again. I'll look at the regulations again. And the other thing is we can ask for an advisory opinion from the Ethics Commission if we really wanted to, and that wouldn't cost us anything. It would just be time. It would take a while to get it. So let me look into that.
That might be a little more difficult than
It might be.
we can talk about that offline, but we might not get a blessing to do that.
We might not get a blessing to do that. And it's, yeah. Cleaner would be to do what we think is right based on our reading of the statutes and regulations, and let the DOJ look over the whole thing once we have a draft, which would also be time consuming. Okay, going to 4D again. The question is whether to empower the commission to allow the public to engage in discussions. Right now, we have public comment. It happens at the beginning of commission meetings. We hear the comment. There's no back and forth with the commentators. But when we had the in-person meeting in Medford, we did have part of the meeting devoted to a discussion with providers in Medford, and that turned out to be a very useful conversation, I think, for the commission. And so the question is whether we should have something specific in the bylaws to empower the commission to allow that when the commission thinks it would be useful. And I put that in there. Comments? Everybody okay with that?
Yeah.
Yeah, all right.
I just want to back up for a second because I just looked at the about the public meeting. So I am right. So a meeting means the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate toward a decision. And a governing body are the members of any public body which consists of 2 or more members with the authority to make decisions. So if there's 2, I mean, like right now, we have a quorum of voting members. So this is a meeting. And we've noticed it as a meeting. That, I mean, we have been very careful about that. But like if I wasn't on this meeting anymore, then it's not a public meeting. It's a subcommittee meeting because there's not a quorum. That's why all the subcommittees have less than a quorum of voting members on them. But we still have been noticing them, and we still have been going through that process to make sure that we're covering everything. But deliberation means a discussion or communication that's part of a decision-making process. And decision means any determination, action, vote, or final disposition upon a motion or ordinance or measure which a vote of a governing body is required at any meeting in which a quorum is present. So we just need to, I think that we need to, whatever language we use in the bylaws should mirror the statute. That's really kind of the bottom line.
Okay.
And that's 192, 610.
When you said before, we are only allowed to have certain kinds of meetings, where were you getting that?
And the definitions, executive session, meeting, and then public notice. There's executive sessions, special, it's 192, 640. So there's executive sessions and special or emergency meetings and regular meetings. Those are the only things that are kind of laid out. It does have a meeting does not include any on-site inspection of a project or program, which wouldn't be us. It's like if we did a site visit. But I got those from the statute.
Right, so that's, I thought that's where you got it. And so, you also just said that we can have subcommittee meetings that don't require a quorum, but that's.
Well, they're not considered meetings if a quorum of voting members are not present.
Okay, so if a quorum of voting members are not present, for example, at a work session or at a subcommittee meeting, then we can discuss whatever we want. Whether it's going to eventually be an action item or not.
I'm not sure about that part of it.
Yeah, I think those are two different thoughts.
Yeah,
Right.
so I'm trying to sort out how we have subcommittee meetings that discuss something that might, for example, right now, we're
You
discussing.
can because subcommittees can have discussions about things that are referred to the public body for deliberation and discussion.
And where do you get that?
I gotta find the statute, but it's in the statute.
Okay, I clearly have to read the statutes more closely, but I thought I had. So you're making a distinction between discussing something for referral and discussing something for decision.
You can't make a decision without a quorum of voting members.
You're making that distinction.
But right.
Okay. I'm taking notes.
There is I'll find it, and you may have actually given it to us. There is like a one-pager I think from the Governmental Ethics Commission that talks about all of this kind of laid out. And you know, the November meeting is probably going to end up being a training session. And I think it would be really helpful if we had the DOJ lawyer who has come to the commission before and done trainings, Christy Monson, if she comes back and does a training for all of us on the commission again about public meetings. We can ask for that specifically because we have to do it every year anyway, and that would be a great thing to have in the November meeting. And then we can ask lots of questions of her while she's there.
Well, I apologize if I didn't pay close enough attention to these distinctions when I was going through and doing this. But
no, I think we're good, but given all of the scrutiny that we've had about all of this stuff, we just need to make sure that it's absolutely spot on right.
I agree with that. And I'm, again, apologize if I didn't pay close enough attention with this first draft, but I'll go through and look at all of that and redo some of the stuff. Um, and we've already talked about whether there should be a new section for work sessions, and we'll turn that into a subsection of commission meetings. Informational meetings, I think you're right. The only kinds of informational meetings we're likely to have would be site visits of some sort where we're going and getting information. And the question is whether under 5B in Article 4, whether we need to specify a time frame for scheduling and posting an informational meeting. We have very few of them. And my guess is that it would be ad hoc, but the question is whether we need to specify how far in advance that needs to be done and
I don't
posted.
think they need to be noticed under the statute. It says specifically that they're not considered a public meeting when you do a site visit.
I understand that they're not, but the question is nevertheless, should we have a time frame for scheduling them and posting a notice? And Paul is saying no, you're saying no.
I mean, I
Corinne?
think it would just be on our regular agenda, right? Good. I mean, or we could just, put out a notice of it. I don't think we need to, like, it wouldn't be something you'd want members of the public to show up to.
Yeah.
So,
All right.
yeah.
All right, so a couple of new thing. Oh yeah, on Article 5. Right now, the current bylaws require a subcommittee to have at least 3 voting members. And I understand that 3 voting members don't qualify as a quorum of the commission. And I don't know why we should require a subcommittee to have 3 voting members. It's very difficult to get 3 voting members to be on a subcommittee. And it's definitely difficult sometimes to have 3 people show up to a subcommittee meeting.
I don't think you need 3 voting members, but you for sure can't have more than 5. You
No,
can't have 5 or more.
you can't have 5 or more.
Yeah.
But does anybody see any reason to have 3? I mean, we went along for a while with only 2 people on the subcommittee on this one. So, okay, everybody agrees about that. Another question on subcommittees being able to refer material to the whole commission. Should there be anything in the bylaws about how a subcommittee decides whether to refer something to the whole commission? Should it be by vote? Should it be just by consensus? Does anybody have any feelings about that?
I don't think you should be voting on anything, just to make sure that we're not confusing anything, anybody with that we're doing something. I think just by consensus.
That's what I would suggest also. All right. The some new questions that aren't reflected in the draft that I gave you all. There's been a suggestion that it might be good to allow some non-commission members to be on subcommittees. The suggestion was that sometimes subcommittees discuss things on which expert input might be useful. Certainly, subcommittees, I think, should be allowed to invite non-commissioners to participate in specific meetings. But other people might disagree about that. And then the suggestion that was made was to consider allowing non-commission members to be members of subcommittees. Any sense of that?
I don't know if you can have We have to look at the statute. I don't know if you can have non-commission members on subcommittees because of, I mean, I would think it might cause a problem with, potentially a problem with whether or not the state indemnifies them, right? If there's some kind of legal action, if they're not an official person on the commission, is there going to be the ability to have indemnification? We don't want to put anybody in a position where they're going to get sued and they don't have coverage for that. But I do know that, and I've just thought of that while I was looking at the statutes where they were talking about indemnification. That's governing of liability of members. So I was like, oh yeah, that's a good point. But I know that there is a section that allows the executive director to convene or to have non-commissioned member, like an advisory type committee.
There's a section in the bylaws that allows the executive director to do that, yes.
Yeah, so I wonder if that isn't a way to accomplish the same thing that you're trying to accomplish.
That's an advisory committee to the agency.
Yeah,
So
that's true.
the question is, and I don't feel comfortable with, I personally don't feel comfortable with having non-commissioned members as subcommittee members, but I think a subcommittee should be able to invite experts to come talk to the subcommittee about something the subcommittee is considering.
I think that makes sense.
Okay, so
I think
invite,
that goes, doesn't that go without saying though? I don't know.
know, does it? I don't know what goes without saying anymore. You're muted, Paul. You're muted. You're still you're still muted. I'm sorry.
Can you hear me now?
Yes, thank you.
Good. Well, I was on my phone. I had a little trouble figuring out how exactly to do that. Um, I forget what the question was, but it just seems to me on all these issues, we're getting way down deep in the weeds. And I don't know why we have to decide all these things. Can't we just leave some of this bureaucracy behind and start doing things and getting things done?
Yes, well, the problem is that we are required to do administrative tasks, and that's what the governance subcommittee is focused on doing. So we have to get these things done so that we then have time to focus on the real issues that we would all like to be discussing.
I would like to spend as little time as possible to get the job done on this minutia.
Okay, well, let's see what we can get through, and hopefully we won't have to do this very much more. And we can turn to the governance subcommittee doesn't deal very directly with the unrepresented persons crisis, for example, but we do have to get through some of these issues. So the next issue, we're done talking about what I've proposed. I'd like to talk about the issue of commissioners who have an actual conflict of interest. So right now, the current bylaws prohibit any voting member from abstaining on a vote. And so the commissioner who has an actual financial conflict of interest on an issue has to announce the conflict of interest. And if that commissioner's vote is needed to break a tie vote, then that commissioner has to vote, notwithstanding the announced conflict of interest. The change that could be made would be to allow the commissioner with a conflict of interest to abstain. And what would happen in that situation let me give an example. Let's say there are 9 voting members and they're all present, and an action item comes up, and one of those 9 voting members has an actual conflict of interest. If that person could abstain, then there would be the possibility of a tie vote, 8-8. And if there was a tie vote, then either that action item would be defeated because it wouldn't be passed, or that action item would have to be tabled and moved to the next commission meeting, where hopefully there would not be an even number of people voting. So as I see it, the difference, the choice that we have is between having to delay dealing with an action item versus having the action item be defeated or adopted based on a vote by a conflicted person.
Except that that's so the law is that section in the bylaws reflects Oregon statute.
Which statute is that?
240, hold on, I'm gonna make sure I'm right. It's 244-120, I believe.
Okay. Once again, I was not familiar with that statute, did not look for it.
If a public official is a member, hold on, a public official. Hold on, I gotta find it. That's not it. That's not exactly it. Oh, that is it. Hold on. Elected a public official, not elected. Or an appointed public official serving on a board shall, it's subsection 2. It's 244-120 subsection 2. When met with a potential conflict of interest, announce publicly the nature of the interest prior to taking any action. When met with an actual conflict of interest, announce publicly the nature of the actual conflict and, except as provided in subparagraph B, refrain from participating in any discussion or debate on the issue or voting. If any public officials, right, or voting, if any public official's vote is necessary to meet a requirement of the minimum number of votes to take official action, be eligible to vote, but not participate as a public official in any discussion.
Well, that's different because it talks about the minimum number of votes. What does that mean?
I think it means a quorum. Right? Let me read that again slowly and see if other people think that. If any public official's vote is necessary to meet a requirement of a minimum number of votes to take an official action, be eligible to vote, but not to participate as a public official in any discussion or debate on the issue.
So what that means is if there are more than 5 voting members there, then there's no problem with abstaining.
The next section says nothing in this section authorizes a public official to vote if the official is otherwise prohibited from doing so. So I don't think you can make them vote if there's a conflict of interest.
Yeah, well, unless.
But you're right about abstaining. I think if you're needed for, well, I guess if there are 5 people present,
then
you don't vote.
Yeah,
but if there are only 5, you're going to have to vote.
Okay, let me try to draft something that's consistent with the statute.
So I think that first section that you read means this. There's 5 people voting. That's a mere quorum. One person is conflicted off. Statute says in that case, the conflicted person's presence counts to achieve a quorum. However, that person still can't vote and still can't discuss. It's merely a body to achieve a quorum. I think that's what that section means.
I think that's right. And I actually looked at, I know we don't use Robert's Rules of Orders, but I looked at Robert's Rules of Orders. maybe I should have been looking at statutes instead of Robert's Rules of Orders, but I did look at Robert's Rules. And it's very clear in Robert's Rules that uh, a conflicted member does not defeat a quorum. I mean, that's very, very consistent with how things usually work. So I'll take a closer look at that, but I think that Rob's interpretation makes so much more sense.
I mean, that doesn't address whether or not that person can vote in a tie, but I would just assume they not vote in the tie and just.
I would just assume they're not voting a tie either, because then it's kind of a bad policy because
Yeah, I think the other members just got to figure it out is all. That's the way it is.
I'll sort it out.
Yep.
And again, if the DOJ disagrees with us, then they can disagree with us. Okay, so the other issue, I haven't touched anything in the existing bylaws about the audit committee. Here, the bottom line issue, Philippe, you haven't been around, so I'll give you some context about this. The audit committee is made up of a bunch of CPA types, made up of the audit chief audit executive from the commission. Rob is the commission's representative to the audit committee, and up until when we came into the executive branch, the audit committee meetings had been private. They have been public since sometime last spring because of an opinion that's indicated that when an audit committee reports to a public body, their meetings need to be public. The audit committee, under the existing bylaws, reports to the commission. The commission is a public body, and so the audit committee has been having public meetings. Some people, at least on the audit committee, would prefer to have private meetings. And so the question has been discussed at some length at the audit committee. We've discussed it on this committee before. And most recently, the suggestion that I saw, and Rob, you can correct me if I get this wrong. The suggestion is that at least some executive branch agencies, audit committees are not public meetings because those audit committees report to the executive director. They do not report to the commission. And then the executive director can report to the commission, but that's a separate kind of a dynamic. So the suggestion that we consider and that the audit committee is evidently going to discuss again is whether the bylaws should be changed to have the audit committee report to the executive director as opposed to being a subcommittee of the commission, which is where it is now, and reporting to the commission. I don't know if we're ready to discuss that. The audit committee is going to discuss it some more at their December meeting, which is their next meeting. They have asked that the governance committee not do anything about it until they have a further discussion. But we can certainly discuss it if we wanted to do that and give some input to the audit committee for their December meeting. And so one person who I heard discuss this suggested that the choice is between the audit committee having to discuss some delicate issues in public versus risking ethics complaint if they do it in private. I've looked at the statute. Here's one statute I did look at, the statute defining executive session, which is 192.660. Nothing leapt out at me as allowing the audit committee to go into executive session. It's very, very clear about when executive sessions are authorized. And one problem that I understand exists if the audit committee reports to the executive director is that then the audit function is no longer independent of management. And so if you have an unfortunate executive director, that can compromise the audit function. So the choice is sort of between forcing the audit function to be extremely public versus risking having some kind of cahoots between an unfortunate executive director, which is not, I think, our current situation, but could be in the future, and the audit function. So if anybody has any feelings about this right now, I'm happy to hear them. If not, I just want you to know that it's percolating.
Let me add to that. There's a couple of challenges to whether or not this audit committee is subject to the public meetings laws. Two things to look at are how is that audit committee appointed? And if the commission appoints them, then it appears more like a governing body. And number two, who do they make recommendations to? And so last week or so, I asked Scott Martin, our internal auditor, chief internal auditor, I guess. I said, I need to know the history of this. Tell me, go back and look at budget notes, go look at this stuff. He dug it up, and a lot of it said the auditor shall report to the commission.
Yep. That's the
And-
way they want, that's the way it was
Yeah,
created.
because it's an oversight function, because of the concern about how the commission was being fiscally handled at the time. And so the legislators made it pretty clear that this internal auditor was going to be independent of the executive director. And so while I understand the desire of some of the auditors, professional auditors, to have a little more confidentiality during their oversight work, but I don't think that fits with what the legislature noted and budgeted for. There was a lot of disagreement or disputes or discussion. I'm sure Jennifer knows more about this than I do, about when these two audit positions were created, who would have control over them and what they would do, and whether they'd be under cap or independent of cap. And I think that what got lost in some of this discussion as I start reading this history is what the legislator intended for this to be versus what management thought would be the best, highest use.
Well, it comports with what I think is the best approach. I think.
Yeah. So I think
all
that,
of this, but I think that that's how it is in the bylaws right now. I'll take another look at whether I think that needs to be tweaked in any other way, and you all can too. But I'm going to suggest that we just leave this, Rob, to you to get the audit committee on board with this and understand what has to happen.
yeah, I think when I have that discussion with them and review the history with the new people on the charter and talk to John and Scott a little bit, I think this will end up being sorted out.
I also think that currently, if we were to change this to secret, the LFO would have some real issues with that in terms of the LFO's relationship with the commission. So
I don't know about that so much, but I do know that there's no question whatsoever that the audit committee was always supposed to be reporting directly to the commission. In fact, they're required by statute to provide a report annually to the commission, not the executive director.
Well, and the other thing I looked at is, they changed the name of, it was the agency, and then the commission was separate, and they changed it to commission, but that was until 2023 under 337. And so when the budget notes say shall report to the commission, there's no, it's pretty clear what that means. It's going to report to this commissioner members, not the agency itself. So
it
I
may
think
even
that
say the chair of the commission.
What's that?
It may even say the chair of the commission.
It might.
Yeah,
but I think
so
this
it's
is
clear.
I think that's correct. And I think that I'll talk to the audit committee. We'll go over this again. I think you're right, Susan. If we leave this the way it is and just move on from this perspective, we may have to come back and do another amendment once we get the audit charter approved. But I think we leave it at this point and move on to the next issue.
I'm comfortable with that. Paul's comfortable with that. Philippe, you good with that? All right.
Really comfortable with that.
There are only two more things on the agenda, and one of them is a commissioner handbook. Um, there's been discussion of having a handbook for new commissioners, and I dare say even for existing commissioners, to lay out some of the things that we need to know. And Mara has started work on putting one together. Um, she includes so far an agency overview, which is a page from the website. She includes the strategic plan that we adopted. She includes the executive director Sanchgrin's letter to the governor setting out a timeline. She includes his response to the governor's April letter, which is the long response. It sets out background with trends in unrepresentatives and case filings, short-term interventions for increasing public defense capacity. She also includes a commission overview, which is a page from the website ORS 151.213, the bylaws, and commission meeting calendar. And she includes Workday multi-factor authentication setup instructions, which are all really good things. I think that there are some other things that I would like to see in a handbook. I asked people on the commission to make suggestions. I have received no suggestions from anyone. uh, I'm happy to lay out the other things that I would like to see in a handbook if you're interested, or if not, um, I can discuss them with Mara, or you can tell me how to proceed.
I missed, because I was looking for my old commission orientation materials, whether or not you listed that she's including public meeting and communication information.
No, and so
Okay, that I think is super important to include.
I absolutely agree, and I've got that on my list. Let me tell you what's on my list, okay? I would like to see the names and titles of people on the agency executive committee. I would like to see the names and titles of the key staff members that commissioners might need to deal with, even if they're not on the executive committee. I might want to see an organizational chart, even though it doesn't have names on it, or if it does. I would like to see the names and the terms of office of the current commissioners. I would like to see if there are any commissioner responsibilities that we need to list to supplement ORS 151.213. I would like to include open meetings laws, other ethics commission information, instructions on how to preserve emails and texts for public records requests. I would like to perhaps see some brief history of the commission, including PDSC, including how many people have been directors of the agency lately and what their terms were, so that people have some context about how we got where we are. I would like to see some history on why we have Mac, even though none of us like it and tried to get rid of it. I would like to see a description of how Mac works, because I think that's very hard for a lot of people to understand. I would like to see a description of the Oregon legislative process, how the legislative process works. And I would like to see the names of key executive branch and judicial branch people who get mentioned frequently in discussions. And I would like to see a list of acronyms. Those are all the things on my list.
I can add some. I think that a budget, just the bottom line legislatively adopted budget over the last 3 bienniums would be helpful, so we could see what that incremental increase has been. A communication guideline, what to do when members of the public or providers contact you, so that people know what they're supposed to do with the emails or text messages or whatever. And then we should include the national workload study and the Oregon study and the Sixth Amendment report, and then the follow-up Sixth Amendment presentation that they gave us in 2023, I think.
I think it was 2023, yeah.
I think those would be very important things for commissioner staff. And we have the strategic plan and the 6-year plan, both you have listed?
Yeah,
Okay.
I think so. But I'll make sure.
But I like your list.
Is there anything else that anybody would like to see in a handbook? Philippe, is there anything, you're the newest, does anything leap
Yeah.
out?
I mean, what I am currently trying to understand is, what the expectations are as far as proactively engaging. Like, we just had a conversation about contacting commission staff, right? So let's say I want to see data. Do I contact the executive director for that? Is that an appropriate thing if I want to email and say, hey, I'd like to see data on this. Can someone of the commission put it together? And just, expectations in that regard. And I don't know how to put it or whether, it doesn't come in a pre-messaged envelope. But so those are what I'm interested in. I think, Jennifer, what you said about, protocols with talking to lobbyists that might reach out or things like that. Those are really important. So those are more, I mean, in how to access the dashboards, things of those natures. But I really do think that from my perspective, it's somehow trying to frame how we're supposed to be engaging with the department and what our role should be when we're not on these meetings, like what kind of work we can do other than review the materials.
So some of those things are in the bylaws, and how to engage with staff is in the bylaws, and that's what I was talking about changing so that what the bylaws do is refer to a protocol that the executive director will put together. And Ken is very comfortable with doing that. He likes that better than us saying how it should work because it gets in the way of smooth agency function. He's going to put that together, and I think he'll do that relatively soon. And it's in the bylaws now for how to communicate with people outside the commission and the agency. Bottom line is the only way you can speak as a commissioner is if the chair gives you that authority. But you can always, and you have to make very clear that you're speaking from your personal capacity, not your commission capacity. But again, if that was laid out very clearly in a handbook, as opposed to expecting people to go through the bylaws, I think, agree with you, that would be very useful. So I will, I mean, Mara's here, and I'm sure she's taking notes, and this is all in the transcript, but I will send her that list that I have and the list of things that you've all suggested, and we'll keep working on, I'll work on that with her. So the only other thing on the agenda,
Paul has something.
Susan, could you just CC us on that stuff?
I can send it tomorrow and ask Mara to send it out to all of you.
Perfect.
Yeah. Again, public meeting rules. Okay, the other thing on the agenda is talking about the executive director performance review. So we absolutely have to do the performance review that DAS requires, and we absolutely have to do it by June 6th, 2026. And so the only thing that we need to talk about at some point, and it doesn't have to be now, with that is just working with staff at the agency to put together sending it out, the mechanics of it, and at some point our committee and the board and the commission will have to decide specific people to send that out to. And the DAS requirements are all set out in your materials that were circulated today. At some point, and we can begin the discussion today, but we certainly don't have to conclude it, we might want to discuss whether the commission should set out performance expectations in addition to the ones that DAS has. And if so, whether we want to have a review of whether the executive director is meeting those expectations, and if so, how do we want to do that? And you've got those materials, and you might want to take a look at it. The question is, it seems to me, would additional information help the commission fulfill its oversight responsibilities? Would additional information help the commission or the commission chair consult with the governor in appointing a new executive director? Beginning in 2026, where the governor can only terminate an executive director for cause, how would additional information affect the governor's exercise of that power? Is any additional information worth the time and resources needed to get it? And who would we be asking to provide the additional information? For example, the DAS does not ask us to get input from any agency staff except people on the executive committee, right? So that's just an example. I think that it's important for us to at least think about those things and at some point come up with a decision to pursue something in addition to DAS or not. Any responses to that?
I think my general inclination on most of the kind of administrative side is to try to make it as unintrusive as possible and as easy for us to do as possible. So, I mean, that's generally the framework I'm looking at things at, and certainly there are good reasons that we may want to like expand, but if it certainly seems like it's taking on a pretty significant administrative task to define what additional parameters in the job description and the oversight function. Which may be somewhere that we do want to spend it, but my initial inclination is that we want to provide as much leeway to ourselves as possible to make decisions that are based reactive. And
I agree with that.
Yeah, and I'm sure Paul agrees with that.
Yeah, less regulations are more better.
Yeah. And I basically agree with that as well. If for no other reason than the time and resources it would take to do it. I will comment that the alternative to that, just in the normal course of events, is if the commission were to start having problems with the executive director in general or about any specific issue, then we would have to find a way to deal with that situation, right? And I'm not sure that the heat of the moment is the right time to put together a method for dealing with that situation. So I don't have any specific suggestions, but worst case scenario is we get into a situation where that is happening and we have to not only deal with the situation, but figure out how to deal with the situation all at the same time. And that worries me.
Yeah, I mean, the last time that happened, um, it was the Wild West.
It was the Wild West, and I think we need to find a way to, I mean, that's what I'm thinking of, right? I wasn't on the commission then, but boy, everybody
Yeah.
in the state of Oregon was aware of what was going on, you know?
Yeah, and I wasn't on there at the beginning. I mean, I was part of the Saturday Night Massacre, right? I came in afterwards, but I mean, that was just the Chief Justice and the chair of the commission just trying to figure out what to do, you know.
We don't want to be there again.
No, but I think as a practical matter, it doesn't really matter. I mean, I hate to, but we don't get to, I mean, we're going to give input, but it's the governor that's going to do whatever the governor wants to do. And if we had, I mean, I'm guessing that if the commission had a big problem, well, look, it's either going to be the commission has a big problem with the executive director and the governor agrees it's a big problem, or the governor and the executive director are aligned and the commission isn't, and then commissioners are just going to leave. I mean, so I mean, if you had like some, really anti-public defense executive director and anti-public defense governor, I mean, that's the extreme situation, of course, then you would have no commission because the commission would say, we're not going to do this, or the governor would put a bunch of commissioners in there that were aligned. And if the commission had a very serious problem with the executive director and felt like the governor needed to know that, my guess is the commission is going to write a letter to the governor telling the governor that they have a problem with the executive director.
What I'm hearing you suggest is that the way the commission would deal with it is just to have the chair or governance committee or someone propose an action item. The action item would be to write a letter to the governor.
Yeah.
And we'd go from there. So that's
Have an executive session where because
Yeah.
the executive session is to decide to evaluate the performance of an executive director, and in the executive session, then they would decide what to do, and they would. I mean, I guess you could put that in there, that if there was a concern, the commission would discuss it in executive session and decide what action to take. I mean, you could have it that broad and just refer to that as a general broad principle
in the bylaws.
in the bylaws. And that would happen anyway, but you could put it in there just as a nod to some process.
I don't.
Well, if anybody, I'm sorry, Rob.
Yeah, my concern with doing things like that is that then someone says something like, well, this is the only way you can deal with it because it says right here. Versus we have a lot more flexibility if we just know we have these rights to go to executive session, take these steps.
Right.
And to me, as Paul has said, and Philippe as well, sometimes less, and Susan as well, sometimes less is better. Give ourselves some flexibility.
Okay. I thought it was important to raise, and we've raised it, and I think it's concluded unless anyone has anything else to say. All right, where we go from here, I will take another stab at amending the bylaws based on what we discussed today, and I will get those circulated before the next governance committee meeting. They'll be posted. I think that I'm going to ask Mara to see if there's another set time now that, I don't know, Philippe, after this meeting, you may decide you don't want to be on the governance committee, but I hope you decide to stay. We'll see if we can find another set time to have a governance committee meeting when we can all make it, as opposed to having to set one up ad hoc every month.
And Paul, I can talk to you too about trying to find a better fit so that you're not, because the governance committee is minutia. It is all of the stuff that you probably don't want to be involved with. It sounds like, and I can talk to you about that.
Yes, we need to talk. I do have some other just momentary discussion that I would like to have with you folks to let you know what's going on in the 10 days or so ahead. I am booked on October 19th at the judicial conference, which is at Sun River. And they give me 15 minutes to speak on how courts can assist in saving indigent defense money. And I want to solicit I'm not going to try and tell them what they ought to be doing. I was presiding judge. I certainly know not to do that to other presiding judges, but I would like to inquire of them what steps they think would be effective in saving court time. And what are they already doing? I know that there are some jurisdictions that are working on the problem, other jurisdictions that aren't. And I just want to convene a short 15-minute discussion with the conference on what they think maybe we should be doing. We're all funded by the same governmental funds, the judiciary, indigent defense, and the prosecution. Everything is funded by the same funder. And so whatever any part of the system can save, not just for that part of the system, but it's also going to save money on the other two parts of the system also. And so I just want to encourage people to come to us with their ideas on where we could save court time and therefore save indigent defense money and prosecution money and judicial time and expense. So
I think that's great, and I really appreciate that. Two things, you should make it clear that you're not appearing in your official capacity just because of all the headache that comes with that. And then also talk to Ken.
Okay.
Because we need to make sure that the information, I mean, you want information to flow from them to you, but they're also going to want information from you. And so you may want to, well, you definitely want to coordinate with Ken about how to talk with the judges and maybe even consider, if he's available, taking him with you, so he can answer any operational questions. Whenever I have to speak to someone and operational issues may come up, I always bring Ken with me, or the executive director, Jesse, I brought with me.
Okay, Jennifer, I really appreciate that. You know, I'm not good at committees. I've always been kind of a lone ranger, and maybe this is a misfit for me to have me here. But I really want to work on these problems and making things better. And I'm not concerned about the minutia. I'm just concerned about gathering ideas and working about what saves time and money. In some jurisdictions, the prosecution may be willing to give judges the authority just to reduce a misdemeanor to a violation on the judge's own uh, perspective on the problem when it comes time to sentencing. That would move cases faster. We're also not doing a very good job for individuals who are low skilled, a long way from the courthouse and have no means of transportation back and forth, and they get hauled in on one misdemeanor after another.
I'm gonna stop you, Paul, because here's the problem. We have 5 voting members and we've not noticed this in a public meeting. So let's you and I have a conversation about this that isn't in this, what is now a public meeting, because we have 5 voting members here. I don't want to run afoul of any public meeting rules. So let's get on the phone and talk to each other. I'm happy to talk with you about this.
Yeah, because I need some guidance. I'm
Sure.
not going to do anything really stupid, but I might make some mistakes that should be avoided. So yeah.
Yeah, I've got your number. I will give you a call. I've got time tomorrow if you've got time.
I would like to see us be able to maybe have a conversation about this in a public meeting though, because I do think one of the themes that I've kind of saw even before I started is just engaging the rest of the stakeholders, the district attorneys, the judges, and understanding it's not a public defense crisis. It's not an unrepresented litigant crisis. It's the criminal justice system. And so the more that we call it the public defense crisis, we're not. So having that conversation
Agreed.
in
To
process
me,
I
would
think
be
we've
helpful.
had that conversation at meetings, for sure, and I agree that we need to do it in a public meeting again. I think one piece of information that would be useful to have is how much of a prosecutor's budget is actually based on state funds versus county funds.
It's going to vary from county to county.
Exactly, but I think that it would be useful to know, for example, in the 6 crisis counties, how that breakdown occurs.
so let's add this to the December, and I say December because we should have a full commission in December. So let's add this to the with new people who, so we can have a new, there'll be 3 new commission members. We can have this discussion with some new, fresh ideas. So Mara's still on the line. We'll add this engaging stakeholders we'll come up with a title for it. And we'll have it in the December meeting to have an open discussion about it.
Okay, and Susan, I want to apologize to you for being less than enthusiastic about the topics today. It's just not my area, and I'm sorry.
I completely appreciate it, and I would much rather be spending my time on solving the problems also, but duty calls.
Yes.
And no apology necessary. We appreciate your frankness. I mean, if it's not a good fit, it's not a good fit. Let's get you doing something you want to do. I'll give you a call tomorrow.
All right, thank you.
Thanks, everybody.
Thank you, everyone.
Thanks,
Thanks for
everyone.
inviting me.
Bye.
Bye.
Glad you were here.